Bună ziua și bine v-am regăsit la ora arbitrajului. Și de această dată, ediția va fi una în limba engleză pentru că avem un invitat din străinătate. We are in the middle of Bucharest Arbitration Days, the first edition of the most important, the most prominent and the most significant event dedicated to international arbitration here in Bucharest. I couldn't have missed the opportunity to have one of the speakers present in our Arbitration Hour event, and it is going to be a very spectacular discussion about the famous ACHMEA decision and especially about the effects, visible and invisible, direct and indirect effects of ACHMEA decision. As somebody mentioned today during the panel dedicated to investment arbitration, we have present the ACHMEA decision himself, Markus Burgstaller, an Austrian lawyer, presently partner with Hogan Lovells in London. And I will stop from saying anything because I want to take advantage of your presence here, and I would kindly ask to say a few words about you and then to move to ACHMEA. First of all, thank you for being present in Bucharest and for accepting the invitation to provide this interview for Arbitration Hour.
Thank you very much, Cosmin. It's a pleasure to be here. It's my first time in Bucharest, and I'm very grateful for the opportunity to come here to the Bucharest Arbitration Days, which is a very good initiative, and I'm very happy to be here. I am not the ACHMEA decision myself. My contribution to that case was that I acted and continue to act for the Slovak Republic in these proceedings. That judgment by the European Court of Justice is well known, in that it decides the question whether an investor from an EU member state can, under an investment treaty, bring a claim against another EU member state, and the European Court of Justice said that there were EU law obstacles to it, and that decision has caused a lot of discussion and has been the subject of many arbitration conferences as well, and we talked about the case this morning as well.
Yeah, prior to actually discussing and elaborating a little bit about ACHMEA, I know that a lot of people from the Romanian arbitration community, especially the young ones, are very interested to find out as much as possible about very successful careers in international arbitration such as yours. Can you briefly present your path in international arbitration, starting as, I suppose, Vienna law graduate and then moving forward towards London?
Happy to. I think my career path is not the stereotype international arbitration career path, in the sense that I've, throughout my studies, focused on public international law and later on EU law as well. So I did graduate from the Vienna University of Law, and then studied in New York as well for a year, postgraduate studies at New York University, and then did a PhD in public international law at the University of Vienna. So I've a strong background in public international law in that is not typical, I think, for many arbitration practitioners who may have a different background. I've then, after finishing my studies, I have joined the Austrian government, where I was an advisor on EU law and public international law in the Prime Minister's office for 4.5 years. So I have had, until the age of 32, not had any arbitration in my professional career. The only crossroad with arbitration that I had was when I was with the Austrian government. I was put in charge in proceedings again before the European Court of Justice at the time, because the European Commission had started infringement proceedings against Austria and other EU member states for upholding bilateral investment treaties with third states. And I was put in charge for these proceedings before the European Court of Justice. But that was not an arbitration by itself. So it took until the age of 32 for me to come really in touch with first-hand arbitration when I moved to London to join my firm, Hogan Lovells, when I joined the arbitration practice there with a clear mandate to work on and develop practice with in particular arbitrations with a public international law background, and that inevitably then leads to a lot of investment arbitration work, because there inevitably questions of public international law will be involved. So whether or not that's helpful for anyone wanting to build a career in international arbitration, I don't know. I think certainly questions of international law, of EU law, and expertise in these fields will help you develop an international career. But the path that I followed is probably not the one that everyone wants or will follow, because it's not your typical career in arbitration.
Yeah. Two more questions. They may seem philosophical or general, but they are exactly the opposite, because this is also a matter of concern for many young practitioners who try to figure out the exact path or the correct direction for their career. Is arbitration a species or a category or a part of dispute resolution? More precisely, should a young practitioner consider specialization in international arbitration as complementary to general dispute resolution skills, or not necessarily?
Well, I think the skills that you apply generally in dispute resolution, like in any court litigation, are fairly similar to international arbitration. There is differences in that, you know, the procedural rules will be different and, you know, the forum will be different, but generally the skills that you develop are very similar. But arbitration or international arbitration is also a sort of different field, in a sense that people who work in the fields oftentimes run into each other, like at conferences like we do today, or you know, have arbitrations together or against each other. So there is then a sort of more sociological, I think, element to it. But if one were to start one's career, I think it certainly helps to have a broader perspective, and because the skills that you develop, you know, can be interchangeable. I think at one stage of your career, you may then, certainly if you live in jurisdictions like the UK or in France, to specialize in one field or another. But there is not a definite need to exclude general dispute resolution work as well.
Mm-hmm. And the second question, how related and on the other hand how different are commercial arbitration and investment arbitration? If you go to conferences, or if you try to read, to sort of grasp superficially certain institutions, one may consider that arbitration represents one single huge thing, with a classification between commercial or investment. Everybody who practices or who gets into both of them knows that there are huge differences. The question would be, should they be considered like two different institutions or matters, or they are one big thing with certain differences that are to be considered?
I think at the moment the latter, in that there is more in common than there are differences, I think. And there are a lot of practitioners who work in both fields. And the skills that you develop, also the people that you meet, there may be a significant overlap. There are, of course, differences as well, in that questions of international law, of public international law, play a significantly more significant role in investment arbitration. Plus, there is inevitably also always questions of public interest concerned. There is always a state party to these proceedings. Of course, there are commercial arbitrations as well with state parties, and public interest is at stake. Yeah. And to that extent, there is not too much difference. And therefore, I would say, as things stand, there is more in common than there is different between the two. if the path of investment arbitration is more one that, say, the European Union wants it to go, in the sense that it is more sort of a system that is developing characteristics that are closer to a court, then the two may diverge a bit further than they currently are. But as things stand, I think there is more in common than there is different.
Okay. Enough with this general introductory part in arbitration, but it is always interesting to understand the view of an experienced counsel in international arbitration. Now let's move to the hot topic, to the ACHMEA decision. In a nutshell, the European Court of Justice has stated that when a state enters into an EU member, of course, enters into a BIT, whereby they accept jurisdiction of an arbitration without the possibility of European courts to verify, to check legally wise the way European law is interpreted and applied, this is a breach of European law. Is it correct?
Yes.
In a nutshell, that's the ACHMEA decision. Now the first question. Prior to your ACHMEA case and you raising the issue before the German court that sent a preliminary request to European Court of Justice, has this idea or this legal theory upheld by the European Court of Justice, had it been used or exploited in practice prior to this case, or it was a new idea that you had in that concrete case?
Well, I think it's clear and it's on record that a number of EU member states have been trying that defense,
yes,
both before international tribunals and before courts.
Yes.
It has never been successful. The way the arguments were presented were, and that may follow almost naturally, from these proceedings before international tribunals, were presented as questions of international law, such as that the Vienna Convention would regulate that if there is a successive treaty, that new obligations, in this case the EU treaty, would override obligations, say, in investment treaties. Now, these sort of arguments were not accepted by tribunals. And then we took on the case. I developed a case strategy with the client in that we had proceedings before national courts, and that is to say the German courts in this case, and that in order for us or for our client to succeed, we have to phrase these questions as questions of EU law. Only then will we stand chances to bring the case up to the European Court of Justice. So the answer is these arguments in other form have been developed and have been presented unsuccessfully, but I think we changed course in order to make sure that we at least stand chances to bring the case up before the European Court of Justice.
So when you took over the case and you were building the strategy, you knew that all the presentation of the arguments was not meant to be successful, or the precedents were against, and you knew that the focus should be on European law, and on the other hand that you have to bring it before the European Court of Justice in order to render that binding interpretation judgment that would actually safeguard this interpretation.
Yes, only if the German courts had significant doubts, or at least doubts about the interpretation of EU law.
And this is the general rule for
exactly for bringing up the case before the European Court of Justice. So the national courts would have to have doubts about the interpretation of EU law as opposed to any other system of law, be it national law or international law. No, it has to be a question of EU law that is decisive or of importance for that court, in this case the German court, to decide the question before it. Only then will there be a chance for a request for a preliminary ruling before the European Court of Justice, and therefore we had to frame the issues in an EU law framework.
Yeah. Another question. You raised the preliminary ruling question before the German courts. The German courts accepted it to send the questions to the European Court of Justice prior to the European Court of Justice rendering the decision. In your soul, you are optimist. You believed they would issue they would answer the questions in the way that you asked it, or the other way around. And I'm asking it, I'm pretty sure that you believed in your case and in your arguments, but the idea is that the impact of this decision is so overwhelming for generally, not for that case, then this would be, in many cases, an argument for the court, even for the European Court of Justice, not to have the courage to issue that interpretation decision. This is the context or the background of my question.
Well, maybe I take one step back and yes, ultimately the German Supreme Court requested a preliminary ruling, but before we went to that stage, we already had a number of years of litigation in that we first challenged the avoidance jurisdiction before the Frankfurt Court of Appeal, did not succeed, went up to the German Supreme Court. The German Supreme Court said, well, there is already a final award, you need to challenge the final award. Challenged the final award before the Frankfurt Court of Appeal. And then again, we're not successful. Went up to the German Supreme Court again, and only then did the German Supreme Court request a preliminary ruling. So we had a lot of rounds of litigation already before we came there. Yeah. But when the German Supreme Court decided to request a preliminary ruling, intuitively, I think, knew that that was half victory, if not more. Because it took, I think, the German Supreme Court, and when you look at the decision of the German Supreme Court when it requested the preliminary ruling, the German Supreme Court was still coming out in favor of the claimants, that is to say, ACHMEA's arguments, as opposed to ours. But it said we have to take them seriously. So we'd rather ask the European Court of Justice. So I think, intuitively, I knew that that was at the very least half of victory for our client. And then there was one setback in that the way European proceedings before the European Court of Justice go is that you have a hearing and then you have what is called an opinion of the Advocate General. And in, I don't know the statistics, but many say in about 90% of the cases, or even higher, the court will then follow the Advocate General's opinion. In that case, the Advocate General came out against my client's position. And that would, in most cases, make you believe, well, if it is the case that in 90% of the cases the court, then that may be it. But when I looked at the opinion of the Advocate General, I sensed that that will not be the end of the road. I did not know, but intuitively I said to myself, I'm not sure whether the court will endorse that view. I had a sense at the hearing as well that the Advocate General's opinion from the questions that we were asked, and I can talk about it because it's a public hearing, I sensed that this would be the Advocate General's view. I was not surprised by his opinion, given the questions he asked and the way the hearing went. But I still thought that we stand at least a 50% chance for the court to be convinced, even after the Advocate General ruled against us.
Mm-hmm. And were there any questions raised by the judges, or it was just a dialogue between you and the pleadings of your pleading and the general counsel pleading?
It was mainly questions by the Advocate General. There were a few questions as well by members of the court, in particular the rapporteur. And
what was their concern? I'm very curious. This is something I haven't read.
I mean, the questions were not too many. Questions were like, if it is the case that you know, the investor-state arbitration clause would be in violation of EU law, why hasn't your client, the Slovak Republic, terminated you know, its intra-EU BIT its intra-EU BITs? Or questions like, why is it that you know, so many tribunals have come out against your client's position? But the questioning of the courts is fairly basic and is not going to go into too much detail. The court may also have been tired by that time, because there were at least, from memory, 15 or more parties intervening. So a lot of member states pleaded before the court, the European Commission pleaded before the court, and they've heard it again and again and again. So they did not have too many questions, and they would be fairly neutral in their questions as well, whereas the Advocate General in his questioning was, I think, coming out for one position fairly clearly.
Yeah. After the issuance of ACHMEA decision by the UCG, you came back to the German Supreme Court, where you won finally the case in the sense that the arbitral award has been set aside.
Yes.
By means of a final judgment by the Supreme Court.
Yes.
Correct?
Yes. The case then comes back to the German Supreme Court, and the way the German Supreme Court had phrased its preliminary ruling made it very clear that once the court comes out, the European Court of Justice, as it did, then there is very little room for argument not to set aside the award. Of course, there were submissions by the parties even after the Court of Justice issued its opinion or its judgment. But the way the German Supreme Court had requested the preliminary ruling made it fairly clear that there is very little room for it to come out other than setting aside the award. So yes, the German Supreme Court set aside the award and also awarded costs to be paid.
That was the end of the story, or you continued to dispute in different forums?
The award was set aside. There are possibilities that ACHMEA still has. As a matter of German law, this is a final and binding decision by the German.
My only question was whether there are any other pending claims now, as we speak, not potential possibilities for ACHMEA to do something in the future.
For these proceedings, that is a final decision by the German Supreme Court.
Okay, so from this, I don't think we are wrong if we say that ACHMEA is the judgment decision, or we can phrase it in the most general wording, with the biggest impact in the last 10 or maybe 20 or maybe 50 years in international arbitration. I don't think we are wrong. I mean, in the sense that it clarified and it established indirectly the solution in one case, that's one thing. I refer to the general impact in investment arbitration. At least to my knowledge, there is no other judgment with a similar broad impact. Now, I would like to discuss about this, let's say, indirect effects, or even as, I don't know, you or Nontas mentioned earlier today, indirect or unwanted effects of the ACHMEA judgment. First of all, is it safe to consider, as it plainly says within its content, that ACHMEA judgment does not affect in any way whatsoever commercial arbitration, or we may imagine or even encounter soon cases where ACHMEA judgment will become one way or another involved in commercial cases? What is your view on this?
The judgment of the Court of Justice in ACHMEA on its face makes it very clear that the court wants its rationale, and that rationale of the ACHMEA judgment only applied to investment arbitration. There are at least 2 paragraphs in the judgment dedicated to the question as to whether it would apply to commercial arbitration, and the court says no, it does not. And it invokes again its line of jurisprudence in other cases with respect to the fact that with respect to commercial arbitration, there is no problem as a matter of EU law for these tribunals to decide questions of EU law. Now, you would not be a good lawyer if you represented a client who is a state or a state entity in a commercial arbitration to seek to convince your tribunal that the ACHMEA judgment may apply to commercial arbitration. And one can see some justification in EU law to run such arguments. But on its face, the ACHMEA judgment is clear. It applies to investment arbitration to the extent that it is based on international treaties, and it does not apply to commercial arbitration.
So it cannot be a direct incidence of the ACHMEA decision. If somebody tries to figure out a smart approach, extending the rationale to different hypotheses, this is something different, but again, it will no longer be a binding EUCG decision. It is going to be a rationale which has another type of effect, if any.
Yes, of course, you can seek to argue it, and as I say, respectable arguments could still be run, I think.
Yeah.
But the court was very clear in that it does not apply to commercial arbitration.
Okay.
So it would have to, the court would have, if in any such case came up to the court would have to really deviate from the ACHMEA judgment if it were to hold that it did also apply to commercial arbitration.
Okay. The first direct and the immediate effect of the ACHMEA judgment would be, apparently, reading it without getting too much into depth or details, would be to prevent arbitral tribunals to uphold their jurisdiction in similar hypotheses. I mean, in, say, ICSID or ad hoc proceedings initiated on basis of intra-EU BIT, according to ACHMEA decision, without, sophisticated philosophy, there should be no jurisdiction of the tribunals. However, in the last, and you know it better than me, 1.5 years, there have been more than 10 cases where ICSID tribunals and UNCITRAL ad hoc or various other formulas of arbitration tribunals upheld their jurisdiction, actually in all subsequent cases after ACHMEA. What is your view on this? And leaving aside your personal view, a sort of objective explanation for the view of, we can say, many tribunals. Probably we discuss about 10 or 12 cases, 3 arbitrators. It means that 30 international arbitrators take somehow the opposite view, or put it differently, the effects of the ACHMEA decision are not so general as they would apparently be.
Yes. First of all, international arbitrators are not bound by the judgment of the European Court of Justice. They have to decide their jurisdiction in that they interpret their basis for jurisdiction and come out one way or another. They have, at the very least, an incentive, if not a duty, to issue enforceable awards. And I think that's the starting point of the discussion. So when you look at the decisions by tribunals after the ACHMEA judgment, you see that these tribunals were at pains, in particular ICSID tribunals, to differentiate the ACHMEA case from the case before them, in that they said the ACHMEA case is a case that was seated in an EU member state country, Germany, under the supervisory jurisdiction of the German courts. We are an ICSID tribunal, we are an international tribunal. Our basis for jurisdiction is not only a BIT, but is also the ICSID Convention, and we are therefore operating under a completely different legal regime, which lets us uphold, jurisdiction, notwithstanding any objections to our jurisdiction based on the ACHMEA judgment. And they are well within their ambit to do that. Whether or not that is convincing from an EU law point of view is a different question. But as a matter of fact, as you rightly say, to the best of my knowledge, there has not been any decision by an international tribunal, in particular ICSID tribunals, that have declined to exercise jurisdiction based on ACHMEA judgment-style objections. Now, there are obviously a lot of repercussions and consequences of the ACHMEA judgment that have not surfaced, at least in decisions, but that's a different question.
Yeah. So, apparently now, as we speak, if we look at the let's stay with this example because it is clearly defined in terms of its premises. We exceed new cases or in similar hypotheses. The arbitrators seem to accept that, first of all, they are not bound directly by the ACHMEA decision, and on the other hand, that various differentiations, and all cases are different, where one way or another, can lead to a different conclusion. We all agree that ordinary courts are bound by ACHMEA decision, of course, of EU members. And then the situation that occurs, and this is the exact reality that many investors face today, is that a sort of parallel reality is built. The international arbitration reality, meaning an award that can be challenged by means of claim to set aside, which is also in that bubble of the international arbitration world. And then when we come to enforcement stage, this is the European Union world where the reality and the decisions of EUCG become binding. Is it normal? Do you find it normal to have two parallel realities which in fact inevitably at some point clash?
Well, we have seen that in a number of other instances as well, that legal orders clash, and that also the European legal order and the international legal order clash. And to the extent that regional organization or supranational organization such as the European Union flexes its muscle in certain policy areas which have to date been mainly regulated by the international legal system, that there is then a clash of these two systems is almost inevitable. The question is, where do we come out from here, and where do we go from here? And I think history is not always a good measure to look into the future, but I think what we will continue to see over the next few years is that there will continue to be a struggle between the two legal orders, the international legal order and the European legal order, as to who has the final say about these questions. And I cannot see that this question will be decided anytime soon. From the perspective of EU law, the question has been decided in the ACHMEA judgment. But the perception in the international legal order has been, as you say, and as we have discussed, very different. And I think this will continue.
Yeah. On the other hand, or this is the reality, we like it or not, this is the reality. On the other hand, I think this is the worst possible scenario. This uncertitude, this clash between two titans who are unable to meet in a certain context so that one gets to be the big winner, actually affects everybody. It affects the investors, it affects the investors who are contemplating to bring investment claims against the states, and apparently the states should be happy for the context, but I'm not pretty sure that they are entirely happy, because they continue to face numerous proceedings, arbitral proceedings and then enforcement proceedings all over Europe and not only, which should not necessarily make a state happy. They are always respondents, and the idea to face multiple tens of proceedings, I don't think it would make any European state happy. So the big challenge would be, but as you say, it is very likely that it will not happen, because it cannot happen, because there is no legal tool to make it happen somehow, is that the unfolding of the events as it looks today will continue for who knows how many years, until, and I'm moving to our next topic, until probably one day, if the European Union will, and the European Union member states will, is in line with the European Union. So if all this happen, probably one day, meaning in 1 year or in 10 years, we are going to have a new system of dealing with protection of intra-EU investments and with a new fora for settling disputes. What do you think about the initiative which is supported by the European Union? And what do you think about the likelihood of having something else in place instead of the old traditional system.
Yes, I think it's fair to say that that sea change will not be put in place overnight, and therefore will continue the struggle that we discussed. From an EU law perspective, I think it's pretty clear that the system that is compliant with EU law ought to be a system whereby investors have to claim damages before national courts under the supervisory jurisdiction of the European Court of Justice. That is the EU legal order. And the European Court of Justice has this made very clear in a number of judgments. Of course, coming from the perspective of international law, and in particular international investment law, that is, in the eyes of many who have been, practicing in this field, a step back, in a sense that they say international investment law was always meant to bring these disputes out of the national courts before an independent international tribunal. But member states, who are the ultimate, arbiters over where the journey goes, need to be conscious of the fact that when they enter into a supranational organization, such as the European Union, that their sovereignty is being curtailed to the extent that EU law, makes it very clear that their rights and obligations under international law are to a significant extent determined by EU law. And by the way, the German Supreme Court, in its final decision, and previously has also made it very clear in that the loss or the partial loss of sovereignty by EU member states when entering the European Union is clear, and therefore the European legal order, which foresees mutual trust in member states' courts, means that investors, if the EU has its way, will then have to first go to the national courts under the supervisory jurisdiction of the ECJ. And we have seen in recent months even a certain slow but still development of an EU investment protection scheme by certain decisions also by the European Court of Justice.
Now, sticking with the view or the proposal or the plan that the European Union seems to have for protection of intra-EU investment. There are voices or even fears that the system, the new protection system, which is on the table now to be discussed, will offer less guarantees and less effective protection than the old one. Is this a legitimate fear or a legitimate view? Of course, it comes from the investors and the councils and the arbitration community, not from the states, who would be privileged if the new regulation would protect the investments in a narrower way, or in any way that would be in the favor of the states and not of the investors. Is this a real issue or only speculations? What is your view?
I think there is a degree of fairness in that criticism, in a sense that most national legal systems, and I don't claim to have an overview of each and every EU member state's legislation, but I think to some extent it's correct to say that the mechanism in place in the national legal orders of EU member states is not necessarily tailored and targeted to exactly replace the mechanism and the protection standards that are in place in investment treaties. So there is, in most national legal systems, of course, something of the equivalent of a prohibition of uncompensated expropriation in place. I haven't done a study, but I'd be surprised if any EU member state would not establish a principle whereby if a state expropriates investments that you have to pay compensation. The question is then how much, and so on and so forth. But whether or not, for example, there is either in national legal systems or as a matter of EU law, each and every strand of what international arbitral tribunals have developed as the fair and equal treatment standard is a different question. Probably ultimate question, of course, is can investors be guaranteed to have justice done before national courts? And that goes to the heart of the problem, probably whether or not the courts in all EU member states live up to a system of fair and independent justice being done to investors. But that is certainly the system upon which the EU legal order is built upon, as we discussed previously.
Yeah. Another interesting discussion, I'd say general throughout arbitration community, is the issue of discrimination between extra-EU investors and intra-EU investors. Now, as we speak, the impact, if any, or the impact, we don't try to define it, the exact impact of ACHMEA decision affects intra-EU BITs, whereas an identical BIT with a country which is not EU member would not be affected. And there are other technical discussions about the discrimination coming or arisen from ACHMEA decision. I go even further. Let's imagine that in 2025, 6 years should be enough to clarify this issue, we have a completely new system of investment protections intra-EU. Whatever EU wants to build and to replace cannot go beyond the borders of EU. The reality, the old reality as we know it, and the investors seem to like it more and more, remains the same. The question is, isn't it dangerous for the European Union itself as an attractive place for foreign investments to compete under this new formula and umbrella with the old reality if there is going to be a huge disparity? Because I can easily imagine that one day after everything becomes clear, a certain company creates an investment tool with the ultimate beneficiary outside EU in order to make sure that it continue to have the same protection that makes him comfortable, rather than stay and play the new game with numerous question marks which arise only from the fact that the game is new and you cannot know from the beginning what is going to happen in various cases. Isn't this a matter of concern for everybody?
I think that may overemphasize the impact of the current international investment arbitration or international investment law system, to the extent that from a broader view and a broader economic view, what matters for the EU is to have a level playing field within the European Union and to remove obstacles of investment, to have a system of the EU legal order in place, and to have one, to simplify matters, one big economic bloc. And questions of the settlement of investment disputes probably is not the prime consideration to build a free of obstacles economy throughout the European Union. To that extent, I think those practicing in the field may overemphasize the importance or lack thereof of investment arbitration. From the EU legal perspective, as I say, there is not a discrimination in a sense that the EU trusts, or at least as a matter of EU law, there is trust in EU member states' courts, in a sense that from an EU law perspective, that is not, so to say, less of protection if you go to the national courts as opposed to an international tribunal. Now, that question of law, that which was also emphasized by the ACHMEA judgment, that mutual trust in EU member states' courts may be different in the perception of some investors who may wish to prefer to go before an international tribunal than before national courts. But then again, here we are back to our original point that we made, namely, if you are an EU member state, and it's always states who enter into international treaties as well, if states or an EU member state or any European state that accedes to the European Union decides to accede to the European Union, that does have consequences.
Yeah. obviously we discuss about something so complicated and sophisticated, and it is not possible, not for us or for anybody else, to draw conclusions or to figure out a miraculous formula. And prior to finishing, I would come back to a more to an easier question, where we let's try to foresee the future in a simpler manner. In the last, I don't know, 5 years, statistics show which is the exact number of new exceed intra-EU cases. What is your view about the next 2 or 3 years? Are the intra-EU investors going to be discouraged in bringing new claims, so the number goes up, down, or is going to be maintained? So this is for this intermediary gray situation. What is going to be the reaction of the potential intra-EU investors in investment claims?
It's always difficult to predict the future, if not impossible, of course.
Yeah.
To the extent that investors now see that the practice of international tribunals seeks to prefer a restrictive interpretation of the ACHMEA judgment, and as we discussed, each and every international tribunal appears to upheld jurisdiction over ACHMEA style objections. And to the extent that this ultimately leads to favorable awards for investors, and one additional end, investors see that these investors ultimately are, if there is, which unlikely is, voluntary compliance, ultimately succeed in, particularly in non-EU jurisdictions, to enforce these awards.
Yeah.
I think the chilling effect of the ACHMEA judgment may be limited. I would find it difficult to understand how EU member states courts could, without problems, enforce intra-EU
or ignore the ACHMEA judgment
awards. But still, most of the and again, I did not do a study, but hearsay has it that, and that also seems sensible, that most EU member states would have significant assets outside of the European Union, and then it will be interesting to see whether non-EU member states courts agree to enforce these awards over the objection of EU member states, over the objections of the European Commission, which tends to interfere and to intervene in these proceedings. And there are a number of these enforcement proceedings going on before US courts at the moment. And to the extent that the US courts agree to enforce these intra-EU investment treaty awards, as I say, the chilling effect may be limited. But that, I think, we do not know at this stage, and we probably will know fairly soon.
Okay. Markus, thanks a lot for your presence in Bucharest, for your presence here, and I would definitely like to have you in 2 or 3 years and to catch up with what future is going to offer us. Thank you once again. La revedere, rămâneți cu bine până data viitoare.
Thank you.